This video is about Rule 4, Venue of Actions. Please study carefully Rule 4 because this is a bar examination area. This is a bar exam topic, or this is a bar exam favorite. So if you look at the past bar examination questions, most of the questions there are about comparing jurisdiction from venue. Examinees are required to compare the concept of jurisdiction as opposed to the concept of venue. So let's start with jurisdiction. What is jurisdiction? Jurisdiction is the authority of the court to hear and determine a case. So when we talk about jurisdiction, it tackles the issue of authority. So whether the RTC, whether the MTC, the Court of Appeals, the Supreme Court, or other administrative agencies have that authority to hear a case. How about venue? Venue is the place where the case is to be heard or tried. So venue refers to the geographical location. The key word is geographical location, in which an action or proceeding should be brought. Remember always that venue is a matter of procedure, whereas jurisdiction is a matter of a substantive law. And also remember that the rules of venue in criminal cases is different from the rules of venue in civil cases. Basic. In criminal cases, venue is jurisdictional. Such is not the case in civil cases. In civil cases, venue is not jurisdictional. So we will go now to Section 1. Section 1, Venue of Real Actions. Actions affecting Title to real property or interest therein, or actions affecting possession of real property or interest therein, shall be commenced and tried in the proper court which has jurisdiction over the area wherein the real property involved or a portion thereof is situated. Forcible entry and detainer actions shall be commenced and tried in the MTC of the municipality or city wherein the real property involved or a portion thereof is situated. So, concerning Section 1, there are 3 things that I want you to remember. First is the definition of real actions that is always asked, in the bar examination questions. That is asked in the bar exams. So, the definition can be found in Section 1. It is there. Number 2 that you have to remember are the examples of real actions. If you read the book of Briano, you have there the examples of real actions, and those are the following are: an action to recover ownership of real property. It is a real action. An action for unlawful detainer, forcible entry, and action publicana. That is also an example of a real action. An action to recover possession of the leased real property and the payment of accrued rentals. That is also considered a real action. And the last item I want you to remember is this: the nature of an action is determined by the allegations in the complaint itself and not its heading or title. So, even if the title of the case is an action for specific performance, but if you read deeply, you will see that his prayer is an action for recovery of real property. The ultimate goal of the case is not an action for specific performance, but for the recovery of real property. Then that action is not considered as a personal action, but rather a real action, because of the rule that the nature of the action is determined by the allegations in the complaint and not its title or heading. Section 2, venue of personal actions. All other actions may be commenced and tried where the plaintiff or any of the principal plaintiffs resides, or where the defendant or any of the principal defendants resides, or in the case of a non-resident defendant where he may be found at the election of the plaintiff. There was a question in the bar examinations wherein the plaintiff is a non-resident of the Philippines. So he is a non-resident. So the question was, where are you going to file said case? What is the venue? So in that case, the venue is not, of course, the plaintiff's residence because he is not a resident of the Philippines, but you file it where the defendant or where any of the principal defendants resides. That's your venue. Section 3 is venue of actions against non-residents. So if any of the defendants does not reside and is not found in the Philippines, and the action affects the personal status of the plaintiff or any property of said defendant located in the Philippines, there are two options. The action may be commenced and tried in the court of the place where the plaintiff resides, or where the property or any portion thereof is situated or found. Please compare Section 2 from Section 3 because the requirement in Section 2 is the defendant is a non-resident. The defendant in Section 2 is only a non-resident. So in Section 2, if the defendant is a non-resident, the option is given to the plaintiff. Whereas in Section 3, aside from being a non-resident defendant, the rules added the criteria of the following: he is not found in the Philippines, and the action affects the personal status of the plaintiff, or the action affects the property of the said defendant, and said property is located in the Philippines. So the rules state that there are two venues to be considered in said cases. That is, the plaintiff's residence or where the property is situated. Section 4 is when rule not applicable. This rule shall not apply, letter A, in those cases where a specific rule or law provides otherwise. So letter A, an example of this is your Rule 66, the quo warranto proceeding. So if the quo warranto proceeding is commenced by the Solgen, the rule states that you have to file it only in the RTC of Manila. So very specific. Quo warranto proceedings commenced by the Solicitor General only in the RTC of Manila. And letter B, this is a bar exam area, bar exam topic, where the parties have validly agreed in writing before the filing of the action on the exclusive venue thereof. So you have to remember three things. First is it must be in writing. The agreement must be made in writing. Second is it was made before the filing of the action, and the venue is exclusive. So this is your Rule 4. Thank you.